The topic for today is must-have website legal protections. Jump in at any point if you have a question. If I don't see it while I'm talking, there will also be time at the end for me to answer questions. I will definitely get to your questions, if not during the presentation, after the presentation. But I'm going to get started because we have some ground to cover. So I want the mantra for today to be legally protecting my website is actually easy, because I know I've been doing this for about 15 years. I know people get very anxious, tight, nervous when it comes to the legal stuff, and it's not as scary and intimidating as you think it is. And you'll see if you happen to have your website up the back end so you can do some of these things along with this workshop, great. If not, you can do it after. But some of these little tricks are not challenging. So I know that you can put them all in pretty easily. The forecast for today, you're going to learn where and when to put the TM symbol and what the purpose of that would even be. You'll learn how to write a correct copyright notice for your website footer and why we even care about that. And we'll get into some copy and pastable disclaimers. I've got a ton for you, and check out bullet points or refund language. And then I'll tell you a little bit about some of my resources if you want a little bit more beyond this workshop. So my disclaimer, what kind of lawyer would I be without one, is that if you have a specific legal problem or a question, please consult with a lawyer. It doesn't have to be me, but it's good to have that personalized one-on-one if you have something specific going on. Hello, I'm Maria Spear Ollis, aka the Lunar Lawyer. I'm a Scorpio Sun, Aquarius Moon, and Gemini Rising. This eclipse is hitting me in just the right spots for those of you who are into astrology. I am also a 1-3 manifesting generator in human design. I don't know how many of you, if you want to raise your hand, if you're into human design. I love it. I just started learning about it in the last couple of years, but fun fact, I am a sacral manifesting generator. All of my children, both of my children, are emotional authorities. And so there's just a lot of emotions in my house. I have 2 young boys. So there are a lot of emotions going around in my house. I did not grow up wanting to be a lawyer. There are no lawyers in my family. My family is mostly Greek American immigrants who came here, started a coffee business to service the Greek diners in Detroit, and grew from there. Like I said, there's no law background in my family. When I grew up, I went to college to be a voice major and sang and was in Broadway shows. I still love show tunes. But at some point during college, I just knew that I couldn't hang. And by that, I had so much stage fright and self-doubt when it came to auditions and things like that. I was like, I cannot do this for the rest of my life. So I started to think about what I did want to do. And that was work with artists and help people to protect their copyright and their rights. And that started with some entertainment law stuff and some traditional legal stuff like litigation. And I used to wear a suit all the time. I also used to have short hair. I really miss it, but that's a story for another day. I was in this kind of more traditional law firm setting. And in 2015, 9 years ago, I decided no more. I don't want this traditional legal setting. I don't want to wear a suit anymore. I want to do my own thing and focus not on litigation and like the stuff when everything's going wrong, but putting things in place beforehand so that if or when stuff goes wrong, it's a lot less stressful. It's a lot less on our nervous system, and it's easier to take care of and dispose of when and if things go wrong. So that is what I focus on now. I've also gotten more into mindfulness, and motherhood has helped me to do that. So in the last, I would say maybe 3 years, I've been focusing a lot on working with coaches, healers, kind of authentic business owners who are doing business differently in all kinds of different ways, whether it's one-on-one services or you have a podcast or you're booking sessions online, all of those things. These are some of my favorite things that some clients have said. Legal fairy godmother is definitely my most favorite, but just not a typical lawyer downtown in a high-rise in a suit. It's just me wearing this astrology dress with lots of zodiac symbols all over it. So all of that said, that's about me. These are the things that fall under my expertise, and it's copyright, which copyright protects creative works. And it's not just art and music, although obviously those things too, but it's things like your lead magnet on your website, your actual website, your blog. captions in an Instagram post. The Copyright Office has said that those are actually copyright protectable. So way to go, Copyright Office, for keeping up with the times. But all of these new things that you don't think of as traditional art per se, but they are copyright protectable. And then there's trademark, which is branding. So copyright, creative, trademark, branding. It's the name of your business. It's the logo that symbolizes your business, but also maybe the name of the card deck that you're creating, or the name of a specific service or course that you're offering. So not just that main brand name, but also maybe different offers that you have under that name. Internet law, which is really a little bit of privacy and data protection, a little bit of online marketing, contracts that have to do with doing business on the internet, like your terms of service, and then contracts. So service-based contracts, or like I said, terms of use and those kinds of things. So this kind of makes up my wheelhouse, my area of expertise. And we're going to start with using the trademark symbol, using that TM. So why do trademarks matter? Who cares? Why do we care about trademark protection? And what it comes down to, the reason that trademark law was created was actually to protect the consumer. It's to protect us when we're making buying decisions, because we can tell when we're going to the grocery store the difference between Coke and Pepsi based on the names and like the visual representation that we see in front of us. And we have associations in our brain with each one, right? Positive, negative, or otherwise. And so trademark law exists to say, hey, you can't create a brand name or a symbol that is too close to someone else who's already existed, because that's not fair to consumers. That confuses consumers, and they can't make accurate buying decisions if you create something that's too close. So that's the why trademarks matter. So I'm curious if you want to say in the chat your answer to this question. True or false? Do you need a trademark registration in order to own a trademark? And the answer would be different if we were in, say, Canada, but we're talking about the US here. So go ahead and put true, false. I'm curious to see what you have to say in the chat. We've got false, no idea. Thank you. I love that. Yes. Okay. So the answer is false. Good job. You don't have to have a registration in order to have protection in your trademark. So when is your trademark? If you don't have to have registration, when do you have those rights? And these are the sequence, the elements that you need. You need to have a brand name or a symbol. There's Nike, and then there's the swoosh, right? So you need to have a name or a symbol. You need to have a product or a service for sale, and it has to be available to the general public. It can't be this private, secret offer. So long as you have those three things connected, you have protection in your trademark. Now, I didn't say that you have to have a registration, and you don't have to use a registration even to use that TM symbol. So if it's not required, why do we care about trademark registration? I won't linger too much on this, but basically, registration gives you a whole host of benefits. There's a public record of it in the trademark office. It gives the trademark office a reason to reject similar trademarks. So if you're registered, then you stand in the way of anybody else who might come along with a similar name. You get protection throughout the United States. Others have to prove that you don't own it rather than you having to prove that you do own it. It's just a whole host of keeping bad guys away and protection for your business. So what does all of this mean for you right now, today? Mic drop. If you're not using the TM symbol right now, then you're doing your business a disservice, because you can use the TM symbol. You don't need a registration to use that TM symbol. You do need a registration to use the R in a circle. That's only for registered trademarks, but TM you can use. And so that's the first box to check today, is to add the TM symbol to your website. What does it do? It tells people who visit your website, I consider this to be my trademark. Now, again, that can be the name of your business, which my hand is going up here because I think of that top part of your website, right? Like the banner or the header or whatever it's called, where you have either your logo or the name of your business or your name or whatever, putting that TM up there, because people who land on your site see, oh, I think that he or she considers this to be their trademark. It also scares people away because people don't know the difference between TM and R. And so some people will see the TM and think, oh, she's trademarked. And we're not going to correct them if that's their assumption, but it's like a shield. It's like a, I have to boo because it's stay away. This is my property. I consider this to be my property. So where to use it, the number one rule is save it for trademark uses. You don't have to put it in every single paragraph in order to have that effect. Like I said, that top part of your website is a good place, or the footer of your website. A lot of times your branding will appear there. Nobody wants to read a paragraph that looks like this. And it's not even necessary for protection. It's really not. So that is thing number one, is to use the TM symbol where your branding, where your name appears in a branding sense, not just in a paragraph. This is my website. And actually, this is not the best example because I could probably make my little TM bigger, but you can see it right there, right after the Lunar lawyers example for you. Oh, and here's the shortcut. I'm used to doing this all the time, but option 2 on a Mac will give you that little TM. And then this Alt 0153 will give you the TM on a PC. And then, of course, use the R if you have a registered trademark. Does this feel doable? Questions so far? 5 check. This feels doable. You probably will have to do this on your website, go into Canva or wherever your logo is and add that little TM next to the logo. Yay, feels doable. Awesome. Yeah, so to pop that into your website, unless you have it in text form, you can go, I'm thinking of, my website is on Squarespace. That's where I would add it. But in footer, yeah, you can definitely add it in the footer. It depends on, let me see, we're gonna go this way. So I'm gonna show you, come on, you got this. Okay, footer. Yeah, so I've got a TM symbol there too on the legal path here, which we'll talk about, but I've got the TM symbol there. But you don't need it in every instance, in every paragraph, just something to keep in mind. Okay, copyright notices. Here we go. Do we all know what copyright protects? I know I touched on it in the beginning, but copyright is for creative works. I love alliteration. So copyright creative. It is music and film and sculpture and all of those traditional things, but also course content, website content, short form video, long form video, all of those things that are now such a huge part of our world that were not part of our world in 1903 when they first enacted the Copyright Act. We were not thinking of these things in 1903, but they are now included as copyrightable things. Here in Nashville, Tennessee, there's a myth of the poor man's copyright. And I think it extends beyond Nashville, but I use Nashville as a funny example because there's so much in terms of songwriting here and just urban legends when it comes to copyright protection. But there's this myth going around that if you mail yourself a copy of something, that's when you have copyright protection. And that is completely false. You don't have to mail something to yourself in order to have copyright protection. What's required is that it lives outside of your head and that it's more than just an idea for something, an idea for a course, an idea for a method. It can't just be an idea, it has to exist beyond that idea. So if it's an idea for a course that fully fleshed out the video elements, the workbook elements, the text, all of the things that go into a course. I keep using courses as an example because it's an online context. For your website, it's your blog posts, it's the text on your sales pages, it's all of that stuff. What's not required for protection, again, is registration. You don't have to register something with the Copyright Office in order for it to be protected. People get in a lot of trouble with photos on the internet, which I know I sent out via email yesterday, and we're not going to linger here too long, but photos on the internet, people think if it's in the Google search, in the Google image search result, when I type free stock photo, then I can use it. And that's just so not true. But anyway, like I was saying, registration is not required for copyright protection, but it does give you bonuses. You get a guaranteed amount of money if someone infringes your copyright. The burden of proof, which sounds really legalese shifts. So you don't have to prove ownership of something if you have a registered copyright. The other side has to prove that you don't own it, which is really hard to do. And then potentially get your attorney's fees if it comes down to a battle, if someone infringes the copy on your website, the photos, the artwork, your course content, whatever it is. So definitely some bonuses to registration. But if it's not required for protection, then why do we care about a copyright notice? There's a thing called innocent infringement. I have the little halo, right? Innocent copyright infringement. And someone can claim innocent infringement if you don't have a copyright notice on your thing, your website, your artwork, whatever. And that would basically drastically whittle down any damages, any money that you're entitled to for copyright infringement, all the way down to $250. And not to hate on $250, I would take that right now today, but it's probably not going to pay for all of your stress and costs and everything that went into enforcing your copyright in the first place. And if your copyright notice is incorrect, if it's not in the right order, if there are elements missing, then it doesn't count as a copyright notice and someone can claim innocent infringement. That is the biggest problem that I see with copyright notices. There's something missing from it or things are not in the right order. So let's write a proper copyright notice. Here are the elements. By the way, you're going to get these slides afterwards, so don't worry about screenshotting, although you certainly can if it helps you to remember. But the first part is the copyright symbol or the word copyright, either one, both work. Then you want the year that the thing was published. So we're talking about websites, the year that your website was published, first published, and then the name of the owner. And this came up actually on one of my Instagram videos earlier this week. Do you list your name, like you, the individual, as the owner, or do you list your business name? And sometimes it can depend on the type of work. If it's a book, then usually it's the actual author's name and not the business. But for something like a website, I will usually use the business name just because it makes sense that for a business website, the business would also own the copyright in that website. But some people prefer to own all of their copyrights in their own personal name, so that's fine too. Now, here's an example. Hello, there's my copyright notice for this presentation slides. But I think we can go for something a little bit better than just the basic copyright notice, especially for a website. So here is kind of a beefed up copyright notice. Okay, copyright, year, your legal name, all rights reserved, not required, but helps. And then the trademark, whatever your trademark is, the property of whatever your legal business name is. Here's another example. The trademark, the legal apothecary, is the property of Somaria LLC. Is the example. Now, for websites, you often see something like this, a date range. And here's why. And we'll use mine as an example. My website went up in 2015. I have no idea how many hundreds of blog posts in the last 9 years. So I want to make sure that all of the content that I've been posting between 2015 and now is included in that copyright. So that's why there's this date range. If my website were brand spanking new and I had no previously existing content, then I would just have 2024 listed as the year. But I don't. So that's why there's a date range. And that's why sometimes you'll see a date range. I think I saw a question come up, but now I've lost the chat box. So I will get to it in a moment. Where do we put this? Probably in the footer. Now, my asterisk exception to that is, and I know we have at least one artist here, but if you're a photographer, if you're an artist, if you have lots of visual elements on your website that you own, that say maybe somebody is looking to purchase artwork or photos or whatever, then you can put the copyright notice, not that big beefed up one, but this one, on your artwork, either on it as a watermark or below it or beside it. I would put it somewhere in the same visual vicinity as where that artwork or that photo appears. So for website purposes, putting it in the footer; for artwork, making sure that quick, cute copyright notice is near the artwork as well. By the way, this is completely free. If you don't have it already, I have a website disclaimer generator. And it's Mad Lib style, just like all of my contract templates and things. But this is the QR code, and you basically pop in information about your website, and it creates this copyright notice and disclaimer to pop into the footer of your website that is customizable to your business. And like I said, it's totally free. So I'll leave this for a second so you can grab the QR code if you like. But really love this thing. I've had quite a few people sign up for it, and it's just so easy. Okay, now we're going to move on. Copyright notice. Does this feel doable? Yes. Do you have any questions about the copyright notice or the year that goes in it or anything like that? Okay, there's my chat. It disappeared. Okay, yay. Shortcut for PC. Oh, I can go back to that. Let's go back. That was for trademark. That. Here you go. Alt 0153. What about on watermarks? Use the TM there. If your watermark has your brand name on it, you can. Yeah, you can. I wouldn't say not to, but it's a preference. I've seen people change the year in website copyright, so we should leave it in the first year. Yes. So like I said, my website, I started blogging in 2015. And so I want to make sure that those early blog posts are covered by my copyright notice. So that's why I have this date range. I hope that answers your question, Crystal. Okay, you can only put the trademark portion of the copyright notice if it is actually registered, right? Or can we use it if we have the TM in place? The trademark portion of the this part, the trademark for legal apothecaries property of summary LLC. No, you don't have to have it registered. I don't have this registered yet. It's pending, but I have it in my notice. Yeah, it's your property, even if it's not registered. Isn't that awesome? Thanks. Thanks, United States. Okay, so we know about the trademark symbol. We know about how to write a correct copyright notice in your footer and why we care about that. So now we're going to get into the nitty gritty of some copy and pastable disclaimers and refund language. So disclaimers. I talk about disclaimers like the wet floor sign for your business. Here's the disclaimer. The coffee is hot. And here's the risk or the unwelcome things. You can burn yourself if you drink this hot coffee. As if we don't know that you can burn yourself drinking hot coffee. But this is the world we live in, guys. Why do we need disclaimers? To cover our butts. Because guess what? I don't know how long ago it was, but this woman ordered a hot coffee from McDonald's and burned herself and then sued McDonald's for the burn that she received from drinking this hot coffee. And McDonald's lost. So that's why you see the disclaimer on McDonald's. I haven't had a McDonald's coffee in probably a really long time, but that's why you see it on there, because they lost this lawsuit. So even though you might think people should know this stuff that's in my disclaimer already, we're just going to do it anyway, because I'm a rule follower and I think we should all follow these rules, because why not? The alternative is worse, right? I've got a lot of disclaimers here that you can mix, match, copy, paste, depending on the context. And I don't want to overwhelm you with information. Like I said, you will receive these slides afterwards, but I'm going to check on these questions. Ooh, earnings disclaimer. That's a really good one. 1992 was the original lawsuit. Okay, a long time ago. But yes. Okay, earnings disclaimer. If you're talking about, and I don't actually have an earnings disclaimer in this presentation, but this is a great question. If you are a business coach or someone who's posting or talking about, here's how much money I earned after I started doing this, that's when I would like to see an earnings disclaimer. And an earnings disclaimer is very similar to a testimonial disclaimer, which we'll get to in these slides. Here's an example of if your website is educational, if you're providing a lot of information, educational information. The contents of this website are educational and journalistic expression, not intended as legal, financial, tax, or medical advice, treatment, or diagnosis. This might be very obvious to you. It might be very obvious to the people visiting your website, but nevertheless, there's a big legalese word. This is something to add to an educational website, especially if you have a blog. If you're offering business-related services, if you're a sales coach, if you're a business coach, all of that, it's very similar, right? Not legal, financial, tax, or medical advice. Outcome, profits, transformation, growth, not guaranteed. Okay. Energy healers. Energetic support is not intended to substitute medical interventions, diagnoses, treatments, or therapies, and you must consult with a trusted healthcare provider, blah, 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 blah. Results vary and are not guaranteed. You're going to see that theme. Effects of the modalities described on this website can be difficult to evaluate. Decision to adapt metaphysical or frequency-related support. I don't need to read all of these aloud to you. I know you all can read, but Just as another example, alternative healers, gotta love this one. Information on the site, blah, 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 has not been evaluated by the FDA. Okay, if you care about such things. Testimonials reflect individual experiences and results are never guaranteed. Results not guaranteed would be a good one to have on an earnings disclaimer. To speak to your question, I think it was Crystal that asked. Physical products. So this is a good one if you're selling something that people can literally add to cart, order, and have delivered to them, right? Textures, finishes, colors, patterns, sizes, other visual features of any products offered for sale on this website may display differently on your computer than items appear in hand. So that's a really good disclaimer to have if you sell physical products. Here's one for crystals. I love crystals. Hello, here's my selenite wand. Affiliate links. I love to have fun with affiliate links. They don't have to be so like hall monitor formal sounding. So here's one example of an affiliate link. Real talk, I received a small commission for products linked on this page at no additional cost to you. I only recommend trusted products I've used myself. Like I said, that's just an example. So where do we put them? Okay, on your website, you can have your disclaimer in the footer. The exception being testimonials and affiliate links. I'm going to talk about testimonials first. So you can have a testimonial disclaimer in your footer, that's fine. But I would also put that little one-liner testimonial disclaimer wherever you have testimonials. That's me, that's my like risk averseness. You'll see it on my own website in my testimonial section. These are individual experiences, results are never guaranteed. I know people think it changes the vibe, whatever. We're also very used to seeing disclaimers. Our eyes are used to seeing, just like they're used to seeing the TM symbol. I had graphic design clients say, I don't want to put the TM symbol, it's ugly. We're just used to seeing it. No one's eyes are going to go straight to that thing. They're going to look at the thing as a whole. So don't let that dissuade you from covering your legal bases. Affiliate links. Affiliate links disclaimers cannot be on their own page somewhere else. If you have affiliate links on your website, you need an affiliate disclaimer where that link appears. If you have one web page that's devoted to all of your affiliate things, having it at the top of that page is fine. You don't have to have it each time you list each affiliate thing. But affiliate links have to be conspicuous, which means hard to miss. And the FTC has said they cannot just exist on their own page. They have to be wherever they are on your website. If you're sending an email with affiliate links, again, that conspicuous rule applies. So remember that about affiliate links having to be conspicuous. That means hard to miss, right? So part 2 of this equation, refund language. Here's a little trivia. This was fun to research. What percentage of people do you think agree to terms of service without reading them? Check the box and they're just like, okay, yeah, whatever. What percentage do you think? Just throw it out there. 90%, 99%, yeah, you're very close. Ooh, herbology disclaimer, that's a really good one too. 98%, 99%, 91. I don't remember where exactly I found this, but 91. This reminded me of one of my favorite late 90s movies, which is called Can't Hardly Wait, where Seth Green's characters, 91% of people agree. I would have thought it was more like 99, to be honest. They're not, yes. My husband, when I signed up for my business credit card years ago, I'm like sitting there and scrolling through and reading it. My husband was like, excuse me, you're actually reading this credit card language? I'm like, yeah, of course. I'm agreeing to this contract. 91%. So how can you enforce rules or policies on someone that's buying from you if they're not reading the thing? If it's just like a link that's sitting there when they're booking something or buying something, you cannot count on them to click on that link, right? Because even when they have to click the checkbox, they're not reading it. So how you enforce rules or policies on someone, they have to know those rules exist before they buy, and they have to agree to those rules before they buy. Because quick little legal primer on contracts, a contract is a promise for a promise. So when you're making an offer, you're making a promise to do or deliver a service or a product. And in exchange for that promise, they are submitting money to you, right? They are giving you money. And they're like, okay, my understanding is that I'm going to get this. And if I pay this, I get this. Any other terms applicable? No? Okay, great. So getting them to agree to something after the fact, or putting it in an email or something, or just counting on that link, just like existing and hanging out there on your website, is not the best option, because they're not actually agreeing to that when they buy it, unless there's that checkbox. So that's what we're going to talk about. They have to know, like I said, your rules exist before they buy. So pulling things out of your terms and conditions that you really want your user to know before they buy, because the likelihood that she's going to read those things are like less than 10%, right? So what should go on that cart page or that booking page? That depends on what they're buying or what they're signing up for. If it's a physical product, then I would call out that refund policy or return policy. And it will sometimes depend on the tech, right? I am in the process of moving my template library over to Shopify, and I had to do like some Googling and some box checking to add that checkbox to the cart close language. If you're using a Calendly or Acuity or some kind of booking software, they're pretty good about having those forms built in, and you can go in and make sure that you have those things. But we're talking about physical products. So making sure you have a return policy visible and that they have to agree to it when they're making their purchase. So here's some examples of return policies for physical products. You can return physical products if you do these things, maybe up to a certain number of days and it's an unused condition, or store credit only, right? That's also an option for a physical product. Or final sale. You think that people should know if something's final sale before they buy? Absolutely, they should. Digital product. So things that you might want to call out if you're selling digital products, like something that's downloadable. Yeah, something that's downloadable. So making it clear that it's your property, that how they can and can't use it. Can they use it in their own business or not? Is it just for personal use? And then again, that return or refund policy. So classic, very valid for digital products because it's a digital product. Let's see, we've got a question here. So if there's a rule on the listing, but no checkbox agreeing to the rules, are the rules enforceable? Nope, because they didn't check to agree. They didn't say that they agree. So that's something. Thrivecart, haven't seen space to enter terms and conditions at the checkout page. Yeah, I'm currently using Samcart, and I had to, even if I was duplicating, this is very technical to Samcart, but even if I was duplicating an original product with all of the settings, I had to go in and make sure that the box was checked to require that checkbox thing in Samcart. It was there in Kajabi, and you could customize it, including it on the sales page instead. Not instead, but definitely including it on the sales page is helpful. Gosh, I've got to think Thrivecart's got it somewhere. You might have to do some Googling. Like I said, on Shopify, I had to do some Googling to make sure that it was more than just, because Shopify too, it was like, it had it there, but it was Shopify's terms and conditions. I don't care about Shopify's terms and conditions. I want my own terms and conditions in there. So you might have to Google and try and find it. But yeah, having the option to add that checkbox is key. Another example for digital products, maybe you'll consider refund requests made within a certain number of hours because it's a library of something or a course or something. And you're like, all right, if it's within 2 hours or 12 hours, they couldn't have possibly downloaded or saved or taken in all of this information. So maybe I would accept refunds in this limited circumstance. If you're booking sessions, one-on-one sessions, healing sessions, whatever, then having that rescheduling policy and that refund policy, again, calling it out. And I will say this, I'm talking about calling things out. If you have a checkbox with your full terms and conditions, and that's required for booking, that's enforceable, right? Because they have to check, and you have a record probably in the system that you're using that they checked that box, right? It's a mandatory checkbox. But I think it's a better practice to call these things out on that checkout page or somewhere, like someone just said, the sales page, making it very obvious to them, especially let's say for booking a session. Like, I want to know what the rescheduling policy is. I appreciate knowing that. And I don't have to like scroll through and find out what the rescheduling policy would be, even if you already have that checkbox thing. So just a recommended practice. It's not a requirement. But here's an example for a session. If you need to cancel or reschedule, you have to provide a certain number of hours notice. Anything beyond that is an improper cancellation. And you will not be refunded if it's an improper cancellation. Basically, if you cancel an hour ahead of time, sorry, tough luck. Maybe that doesn't feel good to you. And maybe you say you can reschedule once, or 3 strikes you're out policy, whatever it is. So what's the difference between terms of use versus privacy policy versus terms and conditions? What's the difference? Terms of use is something specific to your website. And it tells people who are coming to your website what they can and can't do on your website. If your website is just a blog and you're not selling anything from it, I don't mean just a blog, but you don't have an add to cart for anything on your website, then your terms of use tells people things like, you can't use the content of this blog commercially. In other words, I'll give a very specific example. I had a DIY blogger client, and she had this whole DIY post on how to make this specific trinket. A really big corporation started selling trinkets identical to that trinket that I'm sorry, I'm being vague, but it's client confidentiality. A corporation started selling that same exact trinket that she taught people how to make. She has something in her terms of use saying that this website is for personal use, not commercial use. In other words, don't go selling this stuff that I'm teaching you how to make. But that might not be applicable to your website. So it depends on the type of website that you have. So that's terms of use. Terms of use are for your website specifically. A privacy policy, and there are now 12 states that have individual privacy rules. We don't have a national privacy law yet, but there's a GDPR that applies in Europe, and there are all these privacy rules that we're now having to abide by. And it used to be a privacy policy was just do what you say and say what you do. Have a privacy policy and follow it. But now we need things like consent in order to collect someone's information and add them to our email list and target them with Facebook and Meta ads. So now a privacy policy very specifically has to tell people what kind of information you're collecting about them, how you're using that information, and how you're collecting that information and how you're using that information. So those are the must-have things in a privacy policy now. Terms and conditions are different from terms of use because they can apply to things other than your website. Like when someone's booking a session, when someone is signing up for a course, like someone said, I don't remember if it was Crystal, about using Kajabi. Like a lot of times your course doesn't actually live on your website. It's on a third-party platform like a Kajabi or a Circle or whatever. So you would have course-specific terms and conditions as the checkbox on there. They wouldn't be really agreeing to your website terms and conditions because they're not using your website in order to interact with or buy that course. So that's the difference between these 3 things. So that was a lot. Disclaimers, calling out refund language and things like that. Does this feel doable? And I will say that free disclaimer generator that I mentioned that has the copyright notice in it, it also will generate disclaimers for you. So specific to the type of business that you have, the type of business that you're doing on your website. So that will help in terms of disclaimers if you don't want to go back and look at these slides and pick out the disclaimer that applies to you. If you want to use the disclaimer generator, it'll give you a copyright notice and it will give you a disclaimer that applies to your business. Hey, oh yay, I'm so glad, Clarissa. Yay, I'm so glad. I'm glad that you could do a lot during the workshop. That was like my dream for this. I know not everybody knows the back end of their website, but that was my hope that you all would be able to do these things pretty quickly. So I'm going to talk to you about if you need help thinking through these things, if you've got a course, digital products, membership, you're scheduling sessions, you're a multifaceted business. I do have something called the Legal Apothecary, which is the contract template that I've created specifically for coaches, healers, and experts. And I kind of have thought through all the things for you. Here's just an example, website terms of use and a question on what's your refund policy. Here's some examples. You just pick the one that feels most true to you in the business. If you don't see something you like here, then you can pop in your own answer. So here, for example, so here's what the library looks like. And you can, if you need a contract because you're bringing on a client or you're scaling with a one-to-many offer, you choose which document you need at the time. And then, for example, website terms of use. I've started to fill all this out, so I'm not like boring you on this call, but are you selling products? Yes or no? And I've filled this in, but filling in the information, and then digital, physical, one or both. and taking you through all of this. I have one client who said she filled out her privacy policy while holding a crying infant in 1 minute using this template. So that was just like the best thing ever when she told me that. So like I said, multiple choice, Mad Lib style. It's a whole library of contract templates. There's a ton included. I'm adding more. I just added these session booking terms. If you're booking healing sessions or strategy sessions, you have those terms and conditions for sessions. There's corporate client consulting. There's one-on-one coaching. There's stuff for memberships and contests and podcasts and courses. It's meant to be all of the contracts you need to start and protect your business. And there's more to come. So if you were to buy the Legal Apothecary, it includes updates, includes future contract templates. So you can get it. Here's the link. It's $122 a month for 12 months, or one-time payment of $222. Special bonus for you all. If you sign up before Tuesday, October 1st, you'll get a free 30-minute Ask Me Anything legal consultation. It must be booked by December 1st because, spoiler, I am having a baby in December. So I want to make sure and get that session in with you before that time, so we're not lingering out there during when I am holding a crying infant. So we can talk about, if we book that session, we can talk about an upcoming offer that you have and any blind spots. You can look through a specific page on your website, like a sales page, and make some tweaks to it. We can workshop a specific problem you're having with your client. So here's the link again for the library. No pressure, obviously. I just want to give you, if you want that extra help, here is an option for you. And not everybody needs this. Maybe you just want quick and easy website protection, in which case I have this website bundle that has terms of use, has a privacy policy, it has that free website disclaimer generator at a no-brainer price of $122. All of my contract templates, I have these things available a la carte as well. They're all $444 individually. They will always be there. So if you think you're going to start booking sessions in a couple of months, it's going to be there in the shop. But I wanted to especially make this website bundle, the terms of use and privacy policy, super accessible, a no-brainer price. So you can get instant access to this, and of course any updates for $122. I saw a question pop up, and now there it is. Okay. Yay, congratulations. Yes, thank you. Baby number 3. It's going to get wild. Okay. Time to have fun and look at some of your websites. How much time do we have? We have 10 minutes. And I did like a raffle before this started, and you got a sneak preview of, yay, Clarissa, I think this is you, right? Blossoming fertility. So let's look at this one first, and then we'll look at the next one. So I'm going to give you just like my quick hot takes. I love this flower. That's so pretty. Blossoming fertility, TM. You can definitely pop that TM symbol on here. Oh, if you've done some of this well,
yeah, I just added that while we were on the call. So sorry.
Okay, awesome. Yeah, it's not letting me, for whatever reason, it's not letting me refresh. So, and now it's, cancel. Okay, here we go. Okay, so great. So this all looks good. I'm going to go down to the footer here. It's a pretty website. Oh, free fertility affirmation meditation. Download now. So this is something where I didn't really touch on in the training, but if you have a freebie and you have people that are obviously giving you their email address in order to receive something, they should know that they're going to be added to your email list after doing this. And you've got, okay, legal. Maybe you've got a privacy policy here. Terms and conditions. Privacy policy, right? Okay. Okay, so that's good. I would add something here in a perfect world saying that you're adding them to your email address and email list, or you can do the double opt-in. So the double opt-in, I use Flowdesk. I know there's thousands of options, ConvertKit, whatever, where basically when they enter their stuff, they say, send me the free thing. And then they receive an email saying, did you mean to sign up for the, or confirm to sign up for this email list? That works too. But adding something, if you don't want to do the double opt-in, adding something, making it very clear that they'll be added to your email list. If you think that people in the EU might be signing up for this, then it's mandatory that there be some kind of consent, like opt-in consent, that they know they're being added to your email list. I don't have that problem because I'm not licensed in the EU, and I don't think people in the EU are looking for my advice. And I know the tech can be tricky because, like with Flowdesk, they don't make it easy to add something like that. but that's where the double opt-in comes in. So just something to think about. You can add your TM here to this beautiful logo. Blossoming Insider, sign up for emails. So sign up for emails is like a very obvious, like you're signing up for emails, right? But here, when it's a freebie and it's a lead magnet, adding that extra, like I said, disclaimer, like everyone, when you sign up for a freebie that you're going to be added to the email list, but making it very clear is important with these new privacy rules. I don't know why this thing just there it goes. Okay, the double opt-in would cover EU requirements. Yes, because they have to click to consent, and that consent click on the double opt-in counts. So that's good. You've got, oops, now it's showing me stuff when I don't want it to. Could you add a disclaimer that you're not intending to get EU people? That's a great question. And I remember asking this question a couple of years ago when that law came into place in 2018. You can, but your intent doesn't matter. What matters is, are you collecting information from people in the EU? So there's like tools you can use to look for someone's IP address and block IP addresses from the EU, but just adding a disclaimer that you're not intending to get EU people doesn't satisfy that EU law. So hopefully that answers your question. Yeah, great, Clarissa. A couple more minutes. Okay, Paul is the second winner of this. So Paul's website is very different from, this is a service-based website. And this is more products. It's got a shop, it's got a cart. So this is awesome. So we can go and pretend that we are, first of all, also the TM symbol there. We can go in and look at this art. And so I mentioned during the workshop, you can add that copyright notice. You can add it here in the description. It's right beside the artwork, but adding that simple copyright notice with copyright year owner to this. And then we've got, so this is great for the website copyright notice. Copyright, the name and the year are switched. So I would switch those back around. But yeah, having that for the website is great. Terms and conditions, refund policy, privacy policy. Okay, so refund policy. Am I going to have to agree to that refund policy when I check out? I don't know if it's going to make me enter all this stuff to see that. Oh, come on. I don't know. Okay. I'm not going to spend time on the workshop doing that, but whatever software this is, it's not telling me, making sure that checkbox is there, because having it on your website is a great first step. But again, making sure someone agrees when they're purchasing to those legal terms is the most important thing. Okay, we'll go back to the home page, join the newsletter. Again, very obvious. You're signing up for a newsletter. That's when you don't need that checkbox, because if they're putting their information in join the newsletter, then they're consenting to being added to the newsletter. Yeah, great. That wraps up the review. If you're online and you made it this far, send me an email as soon as we hang up and end the call with the words website audit in the subject line, and I'll look at your homepage too, because we are out of time. I'll look at your homepage and make recommendations. Any of the emails that you get from me, you can reply, and it's just me on the other side. The email that you've got with the Zoom link, you can reply to that one and say website audit, and I'll look at your homepage too. It's a thank you for being on live. So recap, we've got the TM symbol, we've got the copyright notice in the footer, we've got disclaimers and refund policy options. I know it's a lot, but also things that can take you 10, 15 minutes after we hang up from this call. Any questions before we close? Thank you all so much for jumping on this workshop. I know that it's not sales strategy or copywriting, but the legal stuff is what I do. So I hope this was helpful to you. Send me a DM or a message. I'd love to hear from you, or an email letting me know what was the most helpful. And thank you all so much for being here.